Why not? Good evening, fellow South Africans and citizens of the world. Now, I received a very, very important email from Eugene, who is the CEO and founder of a security company called Kestrel Security. And I'll put their website address down below so you can speak to him directly or email him just for more information on this. But the title of the email is, "Please help us if you can." And he writes, "We need your help. The government is trying to disarm all security companies." Do you get that? The government is trying to disarm all security companies in South Africa. On the 31st of May, 2 draft regulations amending the Private Security Industry Regulation Act 2001, Act number 56 of 2001, namely Notice 295 of 2019 and 292 of 2019, was published. The effect is to disarm the security industry. Below are comments regarding the most important points in the draft regulation. Comments in respect of the draft amendment regulations in terms of and then he says, note, there were 2 separate draft amendment regulations published on the same day attempting to amend the same regulations. Not to get confused between the two, the one is Notice 295 of 2019 dealing primarily with firearms, and the other is Notice 292 of 2019 dealing primarily with uniforms. The proposed amendments include the following. 2F. Semi-automatic means a semi-automatic as defined in Section 1 of the Firearms Control Act. The Firearm Control Act 60 of 2000, Section 1, defines semi-automatic as follows, meaning self-loading but not capable of discharging more than one shot with a single dispersion of a trigger. Draft Regulation 2F reads, by the insertion, after the definition of restricted firearm, the following definition. Semi-automatic means a semi-automatic as defined in Section 1 of the Firearms Control Act. However, there is no definition of a restricted firearm in Regulation 1 of the regulations that has been amended. So where is this intended to be inserted? There is, however, a definition of a restricted firearm in the Firearms Control Act, and possibly the drafter got confused. 2G of the regulation reads, by the insertion after the definition of semi-automatic with the following definition, shotgun means a shotgun as defined in Section 1 of the Firearms Control Act. Note, Section 1 of the Firearm Control Act has no definition for a shotgun. Regulation 13A, 16. Security business that renders security services require the possession or use of a handgun or shotgun must issue such firearms to a security officer as contemplated in Sub-Regulation 2, only for the rendering of one or more of the following security services. A. Reaction service or armed response. B. Protection of valuables that are being transported. Cash and transit. C. Private investigators services. D. Environmental protection or anti-poaching services. E. Close protection services. And F. Protection and security services at national key points. He then goes on to say, therefore, a security company may not issue a handgun or shotgun to any security officer for any security service outside of those definitions. For example, vehicle tracking, unless you try and massage vehicle tracking into one of the above service categories, which is not defined, as well as armed guarding of any site. So now you have the ridiculous situation where you could have a vault containing 1 billion rand in cash. You are no longer permitted to have armed guards to protect the site. But don't worry, you can still use a paintball gun. But there are now a whole lot of regulations about that too. As the assets are not being transported and it doesn't fit into the categories above. If a security company comes and fetches 100 rand from a vault to take to the bank, they can use firearms, including semi-automatics, as the assets are now being transported, but the site itself, the vault, cannot be protected. Regulation 13A.7, security business may only issue a bolt-action rifle that is defined as a hunting rifle to people involved in environmental protection services or anti-poaching services, and no other security service. Regulation 13A.8, security businesses that render security service, which requires the possession or use of a semi-automatic, must issue such firearm to a security officer only for security services aimed at protecting valuables which are being transported. Regulation 13A.9, the possession and use of a firearm contemplated in Subregulation 8, i.e. semi-automatic, is prohibited in respect of all security services rendered and can only be used by cash in transit or asset in transit operatives, unless recommended by the authority and approved by the Central Firearm Controls Registrar. And then he goes on to say, note, the definition of a semi-automatic firearm used in the amended regulations would include pistols. Therefore, according to this clause, no security company other than cash in transit may carry a pistol, even if they're involved in anti-poaching, armed response, etc., meaning armed response companies will now be limited to using revolvers or shotguns, while it is debatable whether they had originally intended that or it was just caused by careless drafting. In any event, that is the effect. Regulation 13A.10, the possession and use of a firearm on a public or private school premises by a security service provider when rendering security services is prohibited unless stated in a contract that security services provided will require the use of a firearm. Section 13C1M, dealing with offences, reads as follows. Any security provider who possesses and uses a firearm on the public or secondary or private school premises for the rendering of security services is guilty of improper conduct and would be liable to penalties. Now, this is in contrast to Regulation 13A, where they state that the use of a firearm while providing security services on a public or private school premises is permitted if it is stated in the contract that the security service providers will require a firearm. However, they then make an offence to be carrying a firearm on a school premises, irrespective of the fact that there was contract specifically stated that it would be required. This would mean, for example, any armed response vehicle responding to the school would not be able to enter the school even after hours, as the armed response officer would naturally be carrying a firearm. The cash and transit companies would not be able to enter the school premises, and the school staff would presumably have to carry the cash out to the road. Should any teachers or learners be attacked, the armed response officers cannot enter the school premises as he is armed, and also cannot leave his firearm in the vehicle so that he could try and assist unarmed, as this is also contrary to the law. Security companies already have to comply with the Firearms Control Act, as well as the Private Security Industry Regulatory Authority Act, and regulations and related legislation that they are regularly inspected by the designated firearms officer at the local stations, as well as inspectors from the Private Security Industry Regulatory Authority. When they apply for firearms, particularly rifles, they have to go through extensive application processes which is vetted and dealt with in terms of the Firearms Control Act, and there is an appeal mechanism where the matter can be decided before the appeal board. The security companies affected would have made applications to the Central Firearm Registrar, and after the CFR or appeal committee has applied their mind, they have proved that the possession of these particular type of firearms are necessary for their work, and that they have sufficient safeguarding facilities and trained staff, and that they can be issued with licenses, which license have to be continuously reapplied for. During this process, the security service provider has to prove it is a registered, has sufficient qualified staff, and it is necessary and still needs the firearms in question. Now, these new regulations enshrine through the back door to effectively retract all those licenses. At least you would not be permitted to use them. If the government wants to change the law and disarm the law-abiding citizens of its country, then they should attempt to pass a bill through Parliament in the normal legislative process so that all the issues can be ventilated. If they feel that a security company should not have their license with justifiable legal reasons, they can refuse to grant them a license to possess one. Should they believe that they should not have a firearm license, currently, because they are breaking the law, they can seize the firearms and prosecute them. There are procedures in terms of the Firearms Control Act to hold an inquiry and to remove firearms from a security service provider. To decide that any security service that does not involve transporting assets may no longer use a semi-automatic, despite the fact that their particular service may be a higher risk and despite the fact that they have satisfied the central firearm registrar that such weapon is necessary, is completely arbitrary. The idea that security officers are expected to take on gangs of poachers armed with AK-47s with a revolver or a bolt-action rifle or a vehicle tracking team is meant to track and arrest hijackers armed with assault rifles without a firearm, or at best, if you massage the definitions of services, with a revolver, is laughable, as is the fact that it would now be unlawful to have an unarmed guard any premises other than a national key point. Our company, as do hundreds of other regulars, come under fire from gangs of suspects armed with AK-47s and other assault rifles. To say they can apply for a recommendation from PSIRA to be allowed to use a firearm does help. Firstly, on the day this regulation is implemented, it takes effect and the use of firearms will cease, except for those set out above. There is no procedure put in place for applying or what guidelines they would use to make a decision, no time limit to make a decision, and not independent appeal committee to appeal the decision, and only applies to semi-automatics. All these processes exist in the Firearms Control Act already. Crime is out of control. The South African Police Service cannot cope with the level of crime, given the amount of resources they have. That is not in dispute by anyone, including the South African Police Service themselves. The security officers are very often the first to come into contact with armed gangs, armed with assault rifles, and need to protect themselves and the public. These regulations are open for comment until the 30th of June. We encourage you to get involved in opposing these regulations. Submit your comments and contact your Member of Parliament. These regulations affect the very safety of everyone in South Africa. And I'm going to put the link to where you can actually put down your comments. Now, clearly, it appears that they've drafted the documents wrong. And one can understand that with the level of incompetence in South Africa today, that's very probable. But, you know, this is such an important issue because probably the last vestige of safety and security for the average minority person is the security companies. If this ANC government disarms them, how are they going to be able to help protect a family that's been raided by thugs with AK-47s? They can't. This is a complete and utter shambles. So please take the link down below if you're in South Africa and let the government know that they better sort out their legislation. Okay, guys, have a great evening. Please remember to subscribe to be kept informed, ring the bell for the updates, and take care.